In school discipline news, an eighth grader had been disciplined by the school for what the school perceived as a racially insensitive Instagram. And now there is a First Amendment challenge relating to that, which has decided can go forward. So this brings to mind the case of the cheerleader with the Snapchat. F school, F cheer, F life. BL versus Mahoney, which went to the US Supreme Court. And BL won on the idea that this speech was not sufficiently related to school to be disciplined by the school. It wasn't a school event. It wasn't during school activity. It was on our own time, to which the school really can't get involved unless there are some other external considerations. So this lawsuit relating to the Instagram brings that to mind on whether or not we can discipline the school for the school student for the racially insensitive Instagram. Let's learn a little bit more. In 2017, a then eighth grader student at Salrayville Middle School posted a screenshot of a friend with a cosmetic mud mask on her face with the caption, "When he says he's only into black girls," on her Instagram account. So, okay, the friend is wearing this mud mask and she's saying, okay, when he says he's only into black girls. So, okay, that's kind of funny. You know, the idea of blackface. So that's a little bit of a provocative joke. So fun. Apparently, the plaintiffs explained that the relevant post was made on a Finstagram account, a fake Instagram account. So some people apparently have these accounts which are intended for these parody things and other accounts which are real. So she's one of the defenses for the student is this wasn't really my real Instagram account. This was my Finstagram account. Okay, that's interesting. The students said that they did not create the photo or draft the caption. They added their own comment to the post that stated, "Ha ha ha, love her, laughing face, laughing face." So this is perhaps just a repost of what someone else had posted and just sort of a further comment on it. The posted screenshot was from her personal phone while she was at home on an internet network and social media account unaffiliated with the school. The friend in the post did not attend the school. So this brings to mind BL versus Mahoney, right? We have a student acting on their own time, on their own Instagram account. This doesn't concern the school. It's not at a school event. So we're thinking to ourselves, you know, this might be outside the school's ability to discipline based on BL versus Mahoney. In 2017, the board had received a complaint regarding the Instagram post. According to plaintiffs, there were no altercations at the school as a result of the post. No classes were canceled, and there was no need for an assembly to discuss racial issues at the school. So there was apparently no disruption at the school. So if there had been a disruption at the school would have to respond to the disruption. But there being no disruption at the school's ability to act is sort of counterindicated. It has been counterindicated since Tanker, which also dealt with this, right? When there's no real disruption at the school, no real problem, classes can continue. Whatever your goals are as a school does not countermand the student's First Amendment interests. You have ability to function as a school. If you have problems functioning as a school, let us know. But if you don't, and you're just silencing speech for the hell of it, well, that's a bit of a problem. Rather, the sole alleged disruption to the board was to keep a close watch on students in the cafeteria for fear of confrontation, which, to be fair, I would hope that school teachers are always keeping a close watch on the students during cafeteria and every other time. You know, there should be teachers there to watch and make sure that there's no disruptions anyway. So I don't even know how much more of a burden that is. Could you please, watch for this? You should be watching anyway. In 2010, the great state of New Jersey adopted what was known as the Anti-Bullying Bill Rights Act. The act set forth the following definition for harassment, intimidation, and bullying. Harassment, intimidation, or bullying means any gesture, any written, verbal, or physical act, or any electronic communication, whether it be a single incident or series of incidents, that's reasonably perceived as being motivated by either actual or perceived characteristics, such as race, color, religion, ancestry, national origin, gender, sexual orientation, gender identity, and expression, or a mental, physical, or sensory disability, or by any other distinguishing characteristic that takes place on school property at any school-sponsored function, on a school bus, or off school grounds when a school employee is made aware of such actions that substantially disrupts or interferes with the orderly operation of the school or the rights of other students, and that a reasonable person should have known under the circumstances, while the effect of physically or emotionally harming a student or damaging student's property or placing a student in reasonable fear of physical or emotional harm has the effect of insulting or demeaning any student or group of students, or creates a hostile educational environment for the students by interfering with the student's education or by severely or pervasively causing physical or emotional harm. That seems a bit overexpansive, to be quite honest. To the extent it is causing actual disruption at the school, then that might be a perfectly proper thing for the state to do, right? Even Tinker would seem to suggest that that would be proper if it's causing a disruption at the school activity, interfering with classes, interfering with the educational process, causing disruption, then that might be perfectly proper. But that merely causes people to feel an emotional harm, that's especially when you're talking about off school time. Again, if this was on school time, on school events, so you're doing these communications using the school computer, using the school network during school time. So if it was speech that was during school time, you could probably deal with it that way. If it was speech that was causing a disruption in school, you could probably deal with it that way. But this seems to go further than that. This seems to deal with off-campus speech that just merely causes an emotional harm without actual disruption. So this bill's definition seems overly expansive when it comes to the First Amendment interests. So I'm not so sure that all that is legal. In response to the complaints, the board launched an investigation. The board's investigation ultimately found the Instagram post violated the board's policy. The principal of the school and superintendent of the school accepted the specialist assessment. The board then affirmed the determination and rejected the student's appeal of the decision. As a result, the student received a one-day suspension, was removed from student council, prevented from attending a special trip for members of the student council, removed from a role of making the morning announcements at school, and prohibited from attending a school assembly. So yeah, we've taken several adverse actions against the student based on their speech, but it's not clear that the speech is the kind that the school has the right to discipline over. The courts looking at this have concluded that the act and the policy based on the act weren't unconstitutionally vague, but conclude the First Amendment challenge could go forward. So they say that maybe this isn't a problem on the policy as written, but it might be a problem as applied. So fine, right? You can bring a challenge facially, say this is facially invalid, and you can also bring a challenge on as applied, as applies to me. So is this act overly broad in general? Well, this court says no, I'm not sure I agree with them, but either way, we can do an as applied challenge to this particular student. So that's fine. The court writing that here, taking the allegations as true, much like Mahoney Area School District, that's BL versus Mahoney, that I've been talking about this whole time, the Instagram post did not involve features that would place it outside First Amendment's ordinary protections. The Instagram post included a screenshot of a friend with a cosmetic mud mask on her face with a caption when he says he's only into black girls, an additional comment made by the student herself saying, ha ha ha, love her, laughing face, laughing face. The post, while potentially racially insensitive, did not amount to fighting words or obscenity. Yeah, it's definitely neither of those things, right? It's definitely neither fighting words nor obscenity. This is not trying to target a specific person. This is not trying to be instigating. This is not fighting words. This is not obscene. Rather, the post itself indicates it was intended to be satirical, regardless of satirical value. So the degree to which it was satirical is not, of course, dispositive, because you get First Amendment protection even if you're not particularly good at it, and therefore was kind of pure speech to which age, if they were an adult, would receive First Amendment protection, because they certainly would. And there are, of course, countervailing considerations when it comes to a school, but none of those countervailing considerations seem to be here based on Tinker or based on BL. Further, similar to the speech at issue in Mahoney, Instagram post appeared outside of school hours from a location outside school. She didn't identify the school or target any member of the school, and transmit her speech through her own personal cell phone on her own personal account to her own personal friends. These features of speech, while risking transmission to the school itself, nonetheless diminish school's interest. Under BL versus Mahoney, yeah, I think that's completely right. This is basically just BL versus Mahoney all over again. There's nothing targeting the school, nothing targeting the people. This is just free speech on our own time, so improper discipline. The board tried to contend that the social media post was not protected by the First Amendment because the post risks serious disruption. Yeah, that's just the same argument in Tinker. It didn't work in Tinker, it doesn't work now. You need more than mere suspicion that maybe it will be a problem. That hasn't worked since the 70s, and the schools are still trying. The board specifically highlighted that the plaintiffs even alleged that following complaints regarding the post, school administrators had to keep a close watch on students in the cafeteria due to fear of confrontation. Again, I'd kind of be hoping that you're keeping close watch on the students in any event. But considering the guideposts set forth in BL, increased supervision of students likely does not amount to a substantial disruption, particularly since you probably should have been doing it anyway. For the state, in the person of a school official, to justify prohibition of an opinion, it must be able to show it was caused by something more than mere desire to avoid discomfort and unpleasantness, which again is just Tinker. Just Tinker all over again. You can't censor the speech merely because you don't like it, merely because it's a little uncomfortable, merely because it doesn't make you happy. You have to have more. It has to cause an actual problem. It has to cause an actual issue, or use school equipment, or be on school time, or something more that is not present here. This is not going to work. It hasn't worked since the 70s. It doesn't work now. The court continues by saying that whether the Instagram post actually causes substantial disruption by the board, of course, is an issue of fact. So was there actually a problem? You can bring forward facts about actual problems that actually existed. So if there are defenses, then fine. Should discover, further elucidate disruption that was caused, then maybe this was fine. So if you can point to actual problems that actually existed, then maybe, but you better bring it. And based on what we know right now, not so much. So it's not going great for the school as this lawsuit's allowed to persist. Thus, that brings us to the end of the case dealing with the First Amendment challenge to the 8th grader for what the school perceived as a racially insensitive Instagram. Based on the standards in BL versus Mahoney, the famous Snapchat case at the US Supreme Court with the cheerleader, this seems to be an appropriate thing to go for. The school doesn't appear to have any of the indicia that would allow for the school to censor this kind of speech. So the case can go forward. The school can bring forward evidence of actual disruption if they have it. Otherwise, probably should confess error, but we'll see how it goes. And that, at least for the moment, brings us to the end of discussion of this case.